Level 1. The Intern. You are 23 years old. You are in your first year of law school on the East Coast, drowning in debt you try not to calculate too closely. You grew up in a small town where your father worked construction and your mother cleaned houses for people richer than you would ever meet. Nobody in your family has ever set foot inside a courtroom, except as a witness or a defendant. You chose law for one simple reason. You watched a cousin get sentenced to 11 years for a crime you still are not sure he committed, represented by a public defender who had 90 other cases that same week. You decided that day that you would learn the language of the system that took him. You take an unpaid summer internship at a capital defense office instead of the corporate firm your classmates chase. Your parents do not understand the choice. Free labor for people already convicted of terrible things is not the path they imagined for you. You do not fully understand it yourself yet, only that something in you cannot look away. Your supervisor is a woman named Reyes, a defense attorney who has spent 20 years keeping men off death row. She hands you a case file on your first morning, 600 pages thick, and tells you to find one thing everyone else missed. You read until 2 a.m. that night. You find a discrepancy in a timeline nobody flagged in 3 years of appeals. You meet the client for the first time through a plexiglass window. He is 34 years old and has been on death row for 9 years for a crime that happened when he was 22. He does not look like a monster. He looks tired and confused and grateful that anyone still comes to visit him at all. You drive home that night and cannot speak for an hour. You have read about the death penalty in textbooks. You have never sat 3 feet from a man the state intends to kill. The distance between those two things becomes the entire reason you keep going. Level 2. The Public Defender. You are 26. You graduate and take a job as a public defender in a county with one of the highest execution rates in the country. The pay is barely enough to cover your loans. The caseload is closer to 100 clients than the 10 a person could realistically handle well. You learn quickly that justice, in practice, often comes down to who had the time and the resources to actually look at the evidence. You do not have enough of either. You learn to triage, which cases you can save and which you can only slow down. You hate every part of that math, and you do it anyway because the alternative is doing nothing for anyone. Your first capital case lands on your desk in your second year. A man named Dwayne Carter, accused of a double homicide, facing a jury that has already made up its mind before opening statements. The evidence against him is mostly circumstantial, and a single eyewitness whose account changes twice under your questioning. You work 18-hour days for 4 straight months. You lose. The jury sentences him to death in under 3 hours of deliberation. You sit in your car in the courthouse parking lot afterward, and you cannot make yourself drive home. You call Reyes, your old mentor from the summer internship. She tells you the one sentence you will carry for the rest of your career. Losing a case is not the same as being wrong. The system is built to make you feel like it is. Do not let it. You marry a schoolteacher named Grace the following spring. She has watched you come home hollowed out more nights than she can count. She does not ask you to stop. She asks you to let her carry some of the weight with you instead. You do not know how to do that yet. You are learning. Level 3. The Capital Defender. You are 30. You leave the public defender's office and join a small nonprofit firm dedicated entirely to death penalty appeals, funded by donations and grants that never quite cover the work. The pay is worse. The stakes are higher. Every single client on your docket has already been sentenced to die and is running out of legal avenues to stop it. You specialize in the appeals no one else wants, cases with confessions obtained under conditions you would not wish on anyone, cases with junk forensic science that convinced juries decades before the science was ever questioned. You win your first stay of execution 11 days before a scheduled date. You find a report buried in a state crime lab's own internal audit, proof that the hair analysis used to convict your client had been debunked years earlier and nobody had bothered to inform the defense. A judge grants an emergency stay at 11 p.m., 4 hours before the execution was set. You call the prison from a payphone in the parking lot because your cell battery died from the stress of the day. Your client's mother is on the other end of the line when the warden tells her. You have never heard a sound like the one she makes. You carry that sound with you for the rest of your life. Grace gives birth to your first child that same year, a daughter. You hold her in the hospital and think, for the first time, about what it means to be responsible for a life that depends entirely on you. You think about every client's mother you have ever spoken to on a phone at midnight. You understand them differently now. You go back to work 3 days later because the docket does not pause for fatherhood, and the men on it do not have 3 days to spare. Level 4. The Litigator. You are 34. Your reputation grows inside a small, strange world that most Americans never think about until it touches their own family. You win a landmark state appeal, proving that a client's trial counsel had been asleep, literally, during key portions of testimony 15 years earlier. The case makes national news for a week and then disappears, the way these stories always do. You learn that public attention is a flashlight, brilliant and narrow, and it moves on long before the darkness it illuminated is actually fixed. You take on a case that will define the next decade of your life. A man named Elijah Marsh, convicted at 19, based almost entirely on a coerced confession extracted after 14 hours of interrogation without a lawyer present. You find inconsistencies the original defense never had the resources to chase down. You spend 3 years building a case brick by brick, traveling to 4 states to track down witnesses who had scattered, alibi evidence buried in old phone records nobody thought to subpoena. Your daughter is 7 now. She asks why you are gone so much. You tell her you are trying to save someone. She asks if you can save everyone. You do not have an answer that is honest and gentle at the same time, so you give her the honest one anyway. She remembers that answer for years. Your marriage strains under the weight of the work in ways you do not see until Grace names it directly one night. She tells you that you have become someone who is fully present for strangers on death row and only half present for the family in your own house. You do not deny it. You promise to change. You mean it every time you say it. Meaning it and doing it turn out to be very different things. Level 5. The Appellate Advocate. You are 39. Elijah Marsh's case reaches the Federal Circuit Court after his state appeals are exhausted. You argue in front of a panel of 3 judges for the first time in your career, the largest stage you have ever stood on. Your hands shake before you stand, the same way they did the first time you sat across from a client through plexiglass. You do not let the shaking reach your voice. The panel rules 2-1 in your favor, vacating the conviction on the grounds that the confession was constitutionally coerced. The state appeals the ruling immediately. You have won a battle in a war that refuses to end. You start receiving calls from lawyers and journalists and other families whose loved ones sit on death rows in states you have never practiced in. Your name starts to mean something in rooms you have never been inside. A rival attorney named Whitfield, representing the state in several of your ongoing cases, begins publicly questioning your methods, suggesting you manufacture doubt rather than uncover truth. You do not respond to him in the press. You respond in filings, in evidence, in the only language this fight actually respects. He loses more than he wins against you. He never stops trying. Your father dies that winter, quietly, before you can fully reconcile the choice you made all those years ago to walk away from the corporate path he once hoped for you. At the funeral, an uncle tells you that your father kept every newspaper clipping about your cases in a drawer he never mentioned to anyone. You did not know that until the day you buried him. You carry that discovery like a stone and a gift at the same time. Level 6. The mentor. You are 44. You open your own capital defense practice. Small, deliberately so, because you have learned that this work cannot be done at scale without losing the thing that makes it matter. You start training young lawyers the way Reyes once trained you, handing them impossible case files on their first morning and telling them to find the one thing everyone else missed. A young associate named Priya reminds you of yourself at 23, furious at a system she has only begun to understand. You teach her the sentence Reyes once gave you: losing a case is not the same as being wrong. You watch her lose her first capital case exactly the way you lost yours. You sit with her in a parking lot afterward, the same parking lot ritual repeating itself a generation later. You realize with a strange ache that you have become the person who answers that call now instead of the person who makes it. The work does not get easier. You only get more prepared for how hard it will always be. Elijah Marsh's case returns to a state court for retrial after years of appeals. New evidence you uncovered, DNA testing unavailable at the time of his original trial, points conclusively away from him. The state, facing the evidence, offers to drop the charges rather than risk a retrial they know they will lose. Elijah walks out of a courthouse a free man after 19 years, exactly half his life. You are there when he sees open sky as a free man for the first time since he was a teenager. Neither of you can speak for a long moment. It is the single quietest and loudest moment of your career at once. Level 7, the advocate. You are 49. Your work has grown beyond individual cases into something closer to a movement. You testify before state legislatures about wrongful convictions and coerced confessions. You train public defenders across a dozen states in the methods you spent 2 decades refining. You become, without ever intending to, one of the most recognized capital defense attorneys in the country. Quoted in newspapers you once only read, invited to conferences you once could not have afforded to attend as a guest. A case arrives that will consume the next 3 years of your life entirely. A woman named Renata Cole, sentenced to death in a state with one of the fastest execution timelines remaining in the country. Convicted on evidence that includes bite mark analysis long since discredited by the broader forensic science community. Every appeal at the state level fails. Every appeal at the federal circuit level fails. You are down to one option left in the entire American legal system, a path fewer than 1% of capital cases ever actually reach. You decide against the advice of colleagues who call it a lost cause to petition the Supreme Court of the United States to hear her case. Your daughter is 19 now, in her own first year of law school, studying under professors who occasionally mention your cases as teaching examples without knowing she is sitting in the room. She tells you she chose this path partly because of everything she watched you carry home all those nights she could not fully understand as a child. You do not know whether to feel proud or guilty. You decide, finally, that both feelings can be true in the same chest at once. Level 8, the Petitioner. You are 51. The Supreme Court grants certiorari in Renata Cole's case, one of only a handful of capital appeals the court chooses to hear that entire year. The news reaches you by email at 6 a.m., and you read it 4 times before you believe it is real. You have spent 28 years building toward a moment you were never certain would actually arrive. You have 4 months to prepare an oral argument that will last exactly 30 minutes and may determine whether a woman lives or dies, and may also reshape how forensic evidence is treated in capital trials across the entire country for decades to come. You rehearse in front of empty rooms, in front of Grace, in front of your daughter, in front of a retired judge who agrees to grill you with the hardest questions the sitting justices are likely to ask. You barely sleep for 4 months. Whitfield, your old rival, is now representing the state's position at the highest level either of you will ever argue at. 20 years of history between you condenses into 30 minutes on a single morning. You fly to Washington the week of the argument and walk the marble steps you have seen in photographs your entire career, steps that somehow feel both smaller and heavier than you imagined. Level 9, the argument. You are 51 years old, standing at a podium beneath a room full of history. 9 justices in black robes seated above you, the weight of a woman's life balanced on the next 30 minutes of your career. You have one shot to make a room full of the most powerful legal minds in the country understand what you understood the first day you sat across from a client through a plexiglass window. That a system built by humans will always carry human error, and that error becomes irreversible the moment a life is taken because of it. Your voice does not shake. You made sure of that a long time ago, in a car outside a different courthouse, after your first loss taught you the difference between losing and being wrong. You answer questions from justices who interrupt you mid-sentence, who probe every weakness in your argument the way you once probed every weakness in a prosecution's case. Whitfield stands at the same podium an hour later and argues with total conviction that finality in the justice system matters more than the doubt you have raised. You watch the justices' faces and cannot read a single verdict in them. You never can. That uncertainty is the entire terrible shape of this profession, the not knowing, carried for months after the arguing is done, while a decision is written somewhere behind closed doors that will decide everything. You fly home that night and hold your daughter's hand at the airport gate, the same hand you once held as an infant while wondering what kind of world you were bringing her into. She asks you how it went. You tell her the only true answer you have. You tell her that you said everything you had, and now you wait, the way every family of every client you have ever represented has had to wait, the way your own father waited quietly, with a drawer full of newspaper clippings he never once mentioned. Somewhere in that marble building, 9 people are deciding whether the system you have spent your entire life trying to hold accountable will finally answer for one of its oldest mistakes.